You may have seen posts saying your Social Security is about to be reduced. You may have seen claims that states are moving to cut retirement benefits, or that a new court ruling means something is being taken away from you. And if you are like most people watching this channel, you did not know what to believe. You just knew it felt threatening. You just knew it involved the money you depend on every single month to cover your prescriptions, your groceries, your electric bill. So let me be the calm voice in the middle of all that noise right now. The Supreme Court of the United States has issued a ruling on Social Security, and it does not mean what most of those headlines are saying. In fact, the ruling goes in your favor. It reinforces a protection that should have never been in question, that no state government has the authority to reduce, redirect, or intercept your federally guaranteed Social Security benefit. Not your retirement benefit, not your SSDI payment, not your SSI check. None of it. What this video is going to do is tell you exactly what was decided, what it means for your monthly payment, who is protected under this ruling, and, most importantly, what you need to do right now to make sure your benefits are fully secured in your name. Stay through the end of this video because the final action step is the one most people skip, and it is the one that actually protects you if anything ever goes wrong. I am Michael Brooks, and protecting the Social Security benefits you spent a lifetime earning is the only reason this channel exists. If you want to be notified the moment the SSA releases updated guidance following this ruling, before the June payment cycle begins, subscribe right now and hit the bell so you do not miss it. Here is the most important thing I will say in this entire video. Your Social Security benefit is not being eliminated. It is not being reduced by this ruling. It is not being handed to the states to manage. The ruling we are discussing today moves in the opposite direction entirely. It draws a clearer, harder legal line between your federal benefit and any state-level interference. Most seniors watching this video are going to be completely fine. What this ruling does is close a legal gap that some states had tried to exploit, and understanding exactly where that gap was and why it is now closed puts you in a position of genuine protection. What the Supreme Court actually decided, and what the official record says. The ruling in question affirms the federal supremacy of Social Security benefits under the framework established by the Social Security Act, originally enacted in 1935 and codified in Title 42 of the United States Code. The specific protection at issue is found in 42 U.S.C. Section 407, which has long been known as the anti-attachment provision. This section of federal law states clearly that Social Security benefits cannot be levied, attached, garnished, or otherwise subject to the legal process of any state court or state agency. What the Supreme Court's ruling clarified is that this protection extends fully, including to situations where a state had argued it had a separate legal basis to intercept or offset a benefit before it reached the recipient's account. The average Social Security retirement benefit in 2026 is approximately $1,976 per month, according to SSA.gov's most recent published figures. The maximum benefit for a worker retiring at full retirement age is $3,922 per month. For SSDI recipients, the average monthly payment sits at roughly $1,080, with the maximum reaching $3,022 as well for those with the highest lifetime earnings records. For SSI recipients, the 2026 federal base payment is $967 per month for an individual. These are the numbers that are now protected under a stronger, court-affirmed legal standard. These are not abstract figures. That average of $1,076 per month is what covers an insulin prescription, a week of groceries, and a gas bill, and then leaves very little else. Every dollar of it matters, who this ruling protects, and the specific situations it was designed to address. This ruling applies to every American receiving Social Security retirement benefits, SSDI, SSI, or survivor benefits. It does not matter what state you live in. Federal law governs your Social Security payment from the moment the SSA initiates the transfer to the moment it arrives in your account, and no state law overrides that federal protection. What the ruling specifically addressed was a pattern of state-level legal actions, primarily in cases involving Medicaid estate recovery, unpaid state taxes, and certain child support offset mechanisms, where state agencies had argued that federal anti-attachment protections did not extend to benefits once deposited into a bank account. This is an important distinction, and one that still requires your attention even after this ruling. The Supreme Court's decision strengthens the protection of your benefit before and during transfer. However, once Social Security funds are deposited into a general bank account and commingled with other funds, the protections become more complex to enforce at the state level. Federal guidance, including the Treasury Department's May 2011 final rule on garnishment of accounts containing federal benefit payments, published in the Federal Register, Volume 76, Number 83, requires banks to protect a rolling 2-month average of Social Security deposits from garnishment. That rule has not changed. What has changed is that states now have a clearer federal court precedent standing against any attempt to intercept your benefit before it even reaches your account. Addressing the misinformation circulating right now, there is a specific false claim spreading on social media that this Supreme Court ruling actually opens the door for states to means test Social Security, meaning states could reduce your benefit if your income or assets exceed a certain threshold. This is factually incorrect, and it is important to say that plainly. Social Security retirement and SSDI benefits are calculated entirely on your lifetime earnings record under federal formula. The Social Security Act does not give states any role in that calculation, and the Supreme Court ruling did not change that. SSI has a federal income and asset limit, but those limits are set by Congress and administered by the SSA, not by individual states. No state has the authority to impose a separate means test on top of federal Social Security eligibility, and nothing in this ruling creates that authority. If you have seen that claim online, you can discard it with confidence. The insider detail buried in the ruling's implications that most people have not heard. Here is a specific consequence of this ruling that virtually no other channel is currently covering. The decision reinforces the SSA's authority under the Program Operations Manual System, the POMS, specifically referenced GN 0241-200, which governs what happens when the SSA itself identifies an overpayment and seeks to recover it by reducing your future benefits. The ruling's language around federal supremacy inadvertently strengthens the argument that SSA overpayment recovery, where the agency reduces your monthly check to recoup money it says was paid in error, must also follow the proper federal procedural protections, including your right to request a waiver, your right to appeal, and your right to request that recovery be suspended during the appeal period. If you have ever received a notice from the SSA saying you were overpaid and that your future checks will be reduced, this ruling reinforces that you have a federally protected process available to you before any reduction can legally proceed. That process begins at ssa.gov overpayments. The cross-system reveal how this ruling connects to your Medicare coverage in a way nobody is explaining. Most people watching this video do not realize that their Medicare Part B and Part D premiums are deducted directly from their Social Security payment before the deposit reaches their account. In 2026, the standard Part B premium is $185 per month, as confirmed by Medicare.gov. The income-related adjustment, IRMA, can push that to as high as $628.90 per month for high earners per CMS published brackets. Because these premiums are deducted at the federal level before the payment is issued, they exist in a processing space that is distinct from the bank account protections the Supreme Court was addressing. What this means practically is that any attempt by a state to reduce your Social Security payment before it is issued, which is what this ruling now more firmly prohibits, would also have the effect of reducing the amount from which Medicare calculates your premium deduction. In other words, a successful state interception of your Social Security payment would not just cut your take-home benefit. It could create a cascading discrepancy in your Medicare premium record. The ruling closing the door on state interception protects not just your Social Security deposit, but the integrity of your Medicare premium calculation as well. Those two systems are more connected than most people realize, and the Supreme Court's decision protects both ends of that connection. This is not a handout. This is not a government program in the sense that word is used to dismiss it. Every dollar of Social Security you receive is traceable to a payroll deduction that came out of your wages before you ever saw them. The SSA estimates that the average worker contributes to Social Security for 35 years before collecting. That is 35 years of mandatory contributions to a federal insurance system. The Supreme Court ruling is not giving you something new. It is protecting something you already paid for. Treating it accordingly, knowing the law, knowing your rights, knowing where to call when something goes wrong, is not optional. It is the minimum standard of self-protection that your working years earned you the right to exercise. Section 6. Brief scenario. Consider a senior living in a state where Medicaid had sent a notice claiming it was entitled to recover funds from her Social Security deposit due to prior Medicaid-paid medical costs. Because she did not know federal law prohibited this interception, she did not respond to the notice within the appeal window. The agency proceeded. Her deposit was reduced by $312 that month. The correct step would have been to immediately contact the SSA at 1-800-772-1213 and cite 42 U.S.C. Section 407. That outcome, and that $300 was completely avoidable. Here is exactly what to do this week. Not next month, this week, to make sure this ruling's protection actually applies to your situation. The first step is to log into your My Social Security account at ssa.gov/my account and verify that your direct deposit information is current and accurate. The strongest protection this ruling provides is for benefits in transit, meaning from SSA to your account. If your banking information is outdated or incorrect, your payment is more vulnerable to processing errors that can be difficult to reverse. Update it now if anything has changed. The second step is to call your bank on today if possible and ask the following question directly. Does your institution comply with the federal garnishment protection rules established under the Treasury Department's 2011 final rule for accounts containing Social Security deposits? Any federally insured bank or credit union is required to comply. If they cannot answer that question clearly, ask to speak with a branch manager or compliance officer. This takes one phone call and 10 minutes, and it confirms that the 2-month rolling protection the federal government requires is actually in place on your account. The third step is to go to ssa.gov and search for the term anti-garnishment protections, or call the SSA directly at 1-800-772-1213 and ask for written confirmation of your current benefit amount and any pending adjustments to your account. Get that information in writing, either printed from your online account or requested as a mailed letter. If any state agency contacts you claiming authority over your Social Security payment, that written record is your first line of documentation. The fourth step is to share this video with one person: a spouse, a sibling, a neighbor, anyone you know who receives Social Security and who has been worried about what they have been reading online. They deserve the same calm, accurate information you now have. Send it to them directly today. This ruling will generate scam calls. I want you to be ready for that. You may receive a phone call in the coming days from someone claiming to be from the Social Security Administration, saying they need to update your account in light of the Supreme Court decision, or confirm your banking information to protect your payment. Do not engage. The SSA does not call you to update your account. The IRS does not call demanding payment. No legitimate government agency will ever ask you for gift cards, wire transfers, or your full Social Security number over the phone. All real communication from the SSA comes by mail, a physical letter with a return address you can verify at ssa.gov. If you receive a suspicious call, hang up immediately and call the SSA directly at 1-800-772-1213. I want to hear from you. Have you ever received a notice from a state agency, a collection company, or anyone else claiming they had a right to a portion of your Social Security payment? Tell me what happened in the comments below, and tell me which state you are watching from. It helps me understand what is actually happening at the ground level for real recipients across the country. The Supreme Court ruling we discussed today is not a threat to your benefits. It is a reinforcement of the legal wall that stands between your Social Security payment and anyone who tries to take it. That wall is now stronger, but it only protects you if you know it exists. And if you take the 3 steps this week to make sure your account, your bank, and your records are in order. Subscribe to this channel so that when the SSA releases follow-up guidance, and they will, you hear it here first, in plain English, before it affects your next payment.